And what the judge did was he held the lawyer in contempt.
See why we don't trust lawyers? You don't tell the public about this case? Do you have a superior duty to the court and not to your client? Fair question. In Ray versus Murchison, cited at 349 U.S. 133, no man can be a judge in his own case, and no man is permitted to try cases where he has an interest in the outcome, such as contempt of court. The interest which will disqualify a man from trying a case depends on circumstances and relationships. Like if one party has no attorney and the other party has an attorney, that's an unfair disadvantage. And to continue with somebody who might not be well read in the case, it's a mistrial. But this is the case law as to why. The judge can't order you in contempt and then try you and convict you in his own court because he's a party of interest. The interest which will disqualify a man from trying a case depends on circumstances and relationships. A person charged with contempt before a, quote, one-man grand jury, end quotes, cannot be summarily tried. A Michigan state judge served as a, quote, one-man grand jury, end quotes, under Michigan law in investigating crime. The court held that before such a conviction could stand, due process at a minimum was required. As the minimum, the accused be given a public trial after reasonable notice of charges, have a right to examine witnesses against him, call witnesses on his own behalf, and be represented by additional counsel. The question now before us, the Supreme Court, is whether a contempt proceeding conducted in accordance with these standards complies with the due process requirement of an impartial tribunal where the same judge presiding at the contempt hearing had also served as the one-man grand jury, out of which the contempt charges arose. This does not involve, of course, the long exercised power of courts summarily to punish certain conduct occurring in open court. Obviously, if the guy came at the judge, but verbal, okay, maybe knowing about this, he should have had an extra hearing, and he didn't. The one-man grand jury charged White, that was one of the people's names, not his race. Bonus question, if you stay till the end, I'll talk about color of law. So the judge, one-man grand jury, charged White with contempt and ordered him to appear and show cause. The judge, who had been the one-man grand jury, then tried both petitioners in open court, convicted and sentenced them for contempt. A fair trial in a fair tribunal is a basic requirement of due process. That means that these administrative courts, all these judges are trying people in, is fraudulent. And they must be courts of common law. I hereby invoke a court of common law, as I am one of the people. Now, that couldn't happen in that case. I'm just giving you my own commentary. Political view? What's safe? That's what I intend. But a fair tribunal is a basic requirement of due process, and fairness, of course, requires an absence of actual bias in the trial of cases. So if you piss off the judge, they can't go hear it. Oregon? Yes. If you challenge the judge that his order was done administratively and not according to the common law, and then that judge hears the case and denies it, it's a violation. The judges can't do that shit. And they can't claim immunity because it was done with intention, willful and wanton behavior as a custom promulgated by their courthouse. This is a epic proportion problem in the American court system. Yeah, I wonder why I'm on my 15th account, TikTok. I'm going to invoke a court of common law against you motherfuckers. But our system of law has always endeavored to prevent even the probability of unfairness. To this end, no man can be a judge in his own case, and no man is permitted to try cases where he has an interest in the outcome. Go and research the Wall Street Journal, October 2021. 131 federal judges got indicted. There's only 987 federal judges. Check it up on the calendar. You can verify that, fact checkers. 131 of them got indicted for hearing cases they had a vested interest in. To this end, no man can be a judge in his own case. That interest cannot be defined with precision. Circumstances and relationships must be considered, like they have an attorney and I don't. I put in an affidavit and they didn't. You obviously don't have a controversy between two corporations. The affidavit is proof of life. Dead men tell no tales. The court has said, however, that every procedure which would offer a possible temptation to the average man as a judge not to hold the balance nice, clear, and true between the state and the accused denies the ladder of due process. It's a total violation of the Fifth Amendment and in your state, that same state's amendment. So, that's what caused the mistrial. Oh yeah, go and watch his whole video. As promised, why you shouldn't trust attorneys. Read the second paragraph down here. An attorney has a duty to aid in the administration of justice and the court to avoiding error and in determining a cause in accordance with just us and the rules of practice. Uphold the legal process and uphold the authority and dignity of the courts. The attorney's duty to the court is superior to the attorney's duty to a client. Best fucking 10 minutes on the internet, huh?